If you weren't with me a couple of weeks ago, we did part one of this three-part series on Medicaid Spend Down, Medicaid income standards, and Medicaid look back period. So we've dealt with the income. Tonight is about spend down, but I'll recap a little bit of that so you can see how they all fit together. So we're talking about Medicaid spend down. I am Scott Collins, an attorney in Richmond, Kentucky, that deals exclusively with elder law, which relates to Medicaid long-term care benefits, VA benefits, guardianship, probate, estate planning, both simple and complex estate planning, things along those lines. So I will be talking tonight about Medicaid, which will come only from a Kentucky perspective. There are differences in Medicaid rules across all 50 states. So that is something to keep in mind. If you're not in Kentucky and don't have a specific Medicaid Kentucky question, that's okay. Still hang in there and I can get you a referral to another state where somebody is competent to handle your questions. There are differences. They're not always huge differences, but I'll mention one of them tonight so you can see what I'm talking about there. What I do want you to do is just be very careful when you go to get advice one-on-one. Be sure you get an elder law attorney that specializes in Medicaid. Not all attorneys know what the Medicaid rules are and how to apply them. As a matter of fact, you'll get a lot of bad advice. So, with that said, I want to give you a little bit of background about me. You may know me, and if you know me, I have to be careful about your confidentiality. So, I'm going to act like everybody is a stranger to me tonight. I'm not trying to be snooty, but I just want to protect you. If you tell me details and say, "Hey, Scott, remember I was in your office last week?" That's fine. You've gone ahead and opened that door and we can talk, but I can't do it on my own and don't want to do it on my own. The other thing is my background. I am former Army air traffic control, left the military after about 5 years and went into church work for nearly 20 years as pulpit counseling, associate minister work all across the nation from Hawaii to New Hampshire. Family circumstances caused me to need to change direction. Went to law school and I knew exactly what I was going to do with elder law. And so I've done a lot in the elder law community to train other attorneys. The elder law section of the bar belonged to several national groups. But I'm not always about work. I do love historic preservation. So you see there on the slide a couple of the six houses here in Richmond that we have used as offices, and I am restoring them and hopefully return them back to the public. So come and visit, and we'll do a tour together anytime you can. Another thing I need you to know is that there are a lot of people that work inside the firm to support me. You oftentimes don't even need me. You might be better served by one of our other specialists on staff. So we have other attorneys, a lot of other background people, and you can see there the kinds of things we do for you. Can't help you with your divorce or your traffic ticket, but I can help you on these things because that's exclusively what we focus on. Okay, that said, I want to get right to it in a little bit more of a controversial way. You may have heard all kinds of things about Medicaid spend down. On the other hand, you may not have heard that term at all. The bottom line is it is what Medicaid and the nursing home tends to say to you. So if you just go to Medicaid and say, "Hey, my loved one is in a nursing home, I need benefits," they're going to tell you a few of these things. You're going to have to spend everything until you come back to us with only $2,000 left in the applicant's name. You have to sell your home. They will tell you how gifting is a bad idea, that you're going to be penalized for it. That one is true, but there's still a way around it. But the other two are not true at all. Now, if you go to the nursing home, many nursing homes will do your application for free if you're applying for the long-term care benefit. Some of them will even ask you to send mom or dad or your spouse's Social Security check directly to their account. None of these things are things that you should do. They're not good choices for the way to handle this kind of planning. Spin down is not the only way, but what happens is because nursing home gets paid more when you are paying privately, they have no incentive at all for you to qualify for Medicaid as quickly as possible and to save as much money as possible. So they will tell you, of course, spend down is the only way, but that is not at all true. So let me pause a second and just say, what is spin down? Spin down is when a person is applying for Medicaid. They're in a nursing facility or they need in-home nursing care. You apply to Medicaid because that is the only benefit other than long-term care insurance that will pay for that extent of care. And so the evaluation begins. It's different if you're a single person or if you're a married person, what this asset standard is. But Medicaid looks at everything you own: property, your residence, investment properties, 401ks, IRAs, life insurance policies, vehicles, farm equipment, collectibles. Anything you have is going to be scrutinized. And the standard is that a few of those things may have exclusions attached to them, but essentially, any of them not excluded, you can only retain $2,000 value, and they want you to spend all of the rest of these things that you have worked all your life to have. And most of us expect that they're there for your benefit and then maybe to pass on to your children as anyone who would inherit from you. And Medicaid says, no, we want you to spend it on yourself first, then you can come back to us for benefit. But that is not the rule. Federal law says there's a very different way, and in fact, state law does too, a very different way to use those assets, and that is to use exclusions. So spin down is not the only way. Let me get to an example of this. If we were to say very quickly as an analogy, let's say that we have a married couple. Let me go one step further. This one's a simpler slide. If we had a married couple with $300,000 in savings, the way Medicaid looks at that benefit or that asset of $300,000 is they attribute it to, you see here on my slide, CS in the green stands for community spouse. That is the spouse who is living at home. The institutionalized spouse is the one who is needing skilled nursing care. Medicaid takes the $300,000 and they attribute it half to each of you. Well, Scott, what if part of that is in my spouse's name, but most of it's in my name? It doesn't matter. It's always a 50-50 split, regardless of how it's allocated, unless it's a dedicated retirement account like an IRA or a 401k. Otherwise, it's attributable to both. So you split it in half, 50-50. And as I said, the institutionalized spouse is allowed to keep $2,000. Therefore, what we have is that the $148,000 of that can be spent by that spouse. Oops. Now, what about the community spouse? The community spouse does not get to keep all 100 or all of their 50% share. There is a cap of 150,000. Anything above that, they would have to begin spending on that. So there can be spend down twice, once for the institutionalized spouse and one also for the community spouse if you have above this threshold that we're talking about. Now I'm rounding some numbers off right now, but that's what spend down is. So let me back up a slide or two. It is because of that spend down that we really need to start planning, because not only is there the concern for spend down, there are at least 2 or 3 other aspects that I'm very concerned about. We were at a presentation just last week where we talked about gifting, and people are aware of gift tax limits. So if you talk to a CPA or financial advisor or do internet research, you're going to find that there is a gift tax exclusion of $19,000 where I can give $19,000 to my child, $19,000 to my second child, unlimited number of children. As long as I don't go above $19,000, this gift tax limit does not apply. And because of that tax rule, people think that there is no concern about gifting. In fact, gifting a single dollar under Medicaid rules can result in a penalty. I don't want to go too deep into penalty, but let's just say that all a penalty is the amount of money you were giving away, even if it's to anything at all for less than fair market value, is converted to a time factor. So if I give $9,000, I'm going to be denied Medicaid benefits for 1 month. If I gave away a house that was worth $90,000, then I'm going to be denied eligibility for 10 months. Just 90 divided by $9,250 a month equals 10 months worth of penalty. There are other concerns I want to have that we need to plan around beyond just spend down, because estate recovery is another one. People will try to do things to exclude assets. They gain Medicaid eligibility, but Medicaid's estate recovery program has a clawback provision that they can come after anything in your probate to repay themselves for the benefit they offered you. Now, it is the only governmental program that has any sort of repayment to it at all. Even though you paid into Medicare and Medicaid through your payroll deduction, they claw it back. Medicaid in Kentucky only claws back real estate. That doesn't mean they can't claw back other things, but they've just never become efficient enough to worry about the others. So estate recovery on your home is a big deal. I'm going to talk about 8 ways to save the home at the very end of tonight's presentation, but I do want to say right now, while we're still fresh, giving the house to your children is one way to protect from estate recovery, because it's no longer in your name if you need the long-term care benefit. But it does result in the penalty period. But more than that, the problem that it really is worse than the other two is that you're going to then have a capital gain on the property where otherwise it would be excluded. So giving the house in the name of the children is a bad idea. It can be excluded in other ways. So those are the reasons to plan. Now, I do want to just make a little reference to the other rules. You can be over the income limit of $2,900 a month. There's a solution for that. No one makes too much to receive the Medicaid long-term care benefit. Don't get that number, 2,900, confused with the asset number of 2,000. Income and assets are different. How are they different? Income is deposited into your account on a monthly basis. It does not become an asset until 30 days passes. At the end of the 30 days, if you've not spent it, now it becomes an asset. It's now savings instead of income. In the asset column, there are both countable and exempt. So let's talk about some of those. What would you really have to spend down? Anything in a life insurance policy that has cash surrender value of a life insurance policy. Let's say I had a $10,000 policy. I'd been paid into it a number of years, and it had developed $2,000 worth of equity. The death benefit of 10, cash benefit of 2. Medicaid requires me to cash it in or transfer it to a funeral home. And what I'm doing there is I'm losing the $10,000 extra value, the difference between 2 and 10. When I do these two, this is a perfect example of the two options. If I cash it in for 2,000, that's spend down. If I take the $10,000 worth of value, transfer it to the funeral home, I'm converting it to an exempt asset. So I can still keep my $10,000 value. I don't lose the $8,000 value by spend down when I cash it out. So that's a good example of how something can avoid spend down by changing it to an exempt resource. Funeral plans are exempt resources. Jointly titled property are exempt. Placed in a special needs trust are exempt. There's lots of different ways to make things exempt. Contracts are exempt. Life estates are exempt. On and on and on we can go. So that is really what we're talking about to avoid this spin down. So here's my rule. If a married couple comes in and only one of them is needing care, we can save 100% of the money. 100%. Even though when we're talking in the earlier chart I showed you, let's see if I can skip over for just a second. This is what Medicaid would want us to spend. If you had $315 or $1,000 in savings, Medicaid would require a spend down of $155. What we would be able to help with as a law firm is avoid the spending of $155,000 by 100%. We could save all of that money and none of that spend down would be required. So that is the real value of what we're talking about. So let's work through a couple of examples of how this happens, and then I'm going to open it up to some questions. If I had, for instance, a house, I'm a single person, and I enter into the facility, Medicaid requires the spend down of the house. I must sell it. The first rule is upon entry into the facility, I get 6 months grace period to sell the house. They want me to sell the house. Now I've got cash. Then I use the cash to pay for my bill. When my bill, all of my money is gone on paying the bill for a number of months, then I can apply for the benefit. But you don't have to do that. What can happen is you can exercise any one of 8 exceptions to this. So one of the exception, I know my scenario was that I was a single person and have to spend it down. But if you're not single, you simply transfer the house to your spouse. The community spouse still needs a place to live. That excludes the house in 100%. Another option would be able to transfer the house to one of your siblings. So let's say Scott's single, but my brother was living with me, caring for me. That joint cohabitation builds equity. If the sibling has title to the house, I can transfer it 100% to that sibling who has been giving care for me. If they have been giving care for the past 12 months and there's zero penalty. Now, what if it's my child that is caregiving? If the child had been giving care for 24 months, then I can do the same exact thing, no penalty. If there's co-ownership of any way, so let's say my brother and I own this house jointly, brother's not living with me, it still is a joint ownership. It is therefore excluded if my brother says, look, I jointly own this house with Scott and I'm not going to sell it and you can't force me to. All he has to do is write Medicaid a letter saying, I refuse to sell the home, and it automatically becomes excluded. The other thing that does is it completely avoids estate recovery because you cannot attach a lien to his house, this jointly owned house once I die, if it was not his debt to repay. So it protects the home in that way. If I have a child under age 21, they still need a place to stay. I can do it that approach. Or if I have a disabled child, a special needs child, that could be a child of any age. So let's just say my child who's in their 40s, but has developed some sort of disability like kidney failure or a number of things. It could be onset diseases just come out of nowhere, middle life. So that the way to exclude the house. Beware of these last two, though, intent to return home and the attempt to sell. They both work to save the house, but they do not avoid estate recovery. So as long as you are attempting to sell the house, Medicaid must exclude it. Now, there are lots of little check marks that you have, boxes you have to check, that you either have it listed with a realtor, that you are advertising it in an open way, let's say with a sign in the yard that is visible from a primary intersection, that it is advertised for fair market value, that you are receiving calls and taking offers. If you're doing all of those things, then the house gets excluded no matter what, and your benefit continues. The problem is, once I pass away, I still have a lien placed upon the home and the forced sale through the probate process. So it's helping me now, but it actually harms me in the end. You can avoid that option. The other thing comes back to haunt us is the intent to return home. I can assert that I intend to return home if I'm able to recover. Medicaid goes back and forth on this rule. It used to be that they declared must have not just the intent, but the physical ability. Therefore, a doctor must sign a letter stating that I had the potential of recovering to the extent that would allow me to return back home at some point for this one to attach. Nevertheless, it does involve estate recovery, so you're going to lose the home eventually. But there are 8 ways to sell the home. Any one of those would work. Some of them have no tax consequences. Others have a pretty significant tax consequence, but I'd rather pay $20,000, $30,000 of taxes rather than lose the home altogether. but I've got to have a way to pay for that tax. So there's a need to save the money in other ways. So let's talk about a couple of the others. How do we save at least 50%? So we'll use the scenario again. I got a married couple, $300,000 in savings, and we have money attributed 50-50 to the healthy spouse, that is the community spouse, and the institutionalized spouse. And the spend down required is this $148,000. The $148,000 could be given away. Let's say I just want to put it in a trust where they can't do anything to the money, can't claw it back, no estate recovery. That $148,000 is going to create a penalty when I place it in trust. But there is a method that I can take. And with that, I can accept the penalty and cut the penalty in half. So if I had $148,000, my handy dandy calculator out here, dividing it by the penalty divisor, if I place that 148 into a trust, Medicaid is going to establish a 16-month penalty, but I can always cut the penalty in half. And so what that means is I'm going to serve 8 months of a penalty, and of my $148,000, I will pay the nursing home bill privately for 8 months. If I do that, I still would have $75,000 out of that $148,000 in the trust that I did not pay the nursing home bill with. So I still have that cash on hand. I still have a cushion for myself. So I can always save at least 50% using that method. However, I could also do the same thing if I create a loan. I could take all $150,000, create a loan to a person, and have the payment go to my spouse instead of myself. And that method of loaning or annuitizing the money would save 100% of it, and there would be no spend down involved whatsoever. Either one of the methods work. There's going to be a problem or two. Let's say the community spouse is not doing too well, him or herself. What if they are receiving payments back from this annuitized money and they need care themselves within the next 12 months or something like that? Well, then you're going to lose that money. But if they are healthy and going to be at home a number of years, then we don't have any worries there. And in fact, as soon as we create this method, establish eligibility for the institutionalized spouse, I would move right to step 2 and then start pre-planning for the healthy spouse and see if we make the 5 years. And that's what we'll talk about next time. 2 weeks from now, we're going to do the whole topic of the 5-year look back and how you use the look back's other conditions so that we can go ahead and pre-plan and make as much value or savings for your hard-earned money as possible. So those are just 2 examples. I want to summarize, and then we're doing question and answers. So I've already established the person needing care can only have $2,000. But the way you want to think about this in terms of spend down, if the total amount of assets that the couple, or this is only for a couple now, I'll go step 2 to single individuals. If the couple has less than 31,584, I typically just round it off to 30,000 to make communication simpler. Less than 31,584, and the healthy spouse keeps all, there is no 50-50 split and a spend down. If it's more than 159, that's why we did the one scenario with 318 and that really odd number, then even the community spouse is going to be required to do a spend down as well. But if it's anywhere in between 31,584 and the 50% attributed to the community spouse is not above 157,920, then it's going to be a simple 50-50 split. Community spouse keeps everything attributed to him or her, and then there's only spend down for the institutionalized person. So that's the way this works. And with that said, why don't we go ahead and I'm going to put contact information on the screen while you begin asking. If you're the one who's in good shape, but the other needs full-time care, is it legal to get a divorce and let the person in good shape keep the assets? I've seen a couple of attorneys practice this pretty aggressively. Is it legal to get a divorce? Yes, it is. It can be a bit more complicated than that. I'm not an advocate of getting the divorce. I think, first off, it's going to be expensive. It's going to take time. We'll fight it if it's not done in advance. They're going to say it was done exclusively for the purpose. That could trigger the fight, but they're still not going to be able to prevent you from doing it. If, on the other hand, the spouse needing care has cognitive decline, they're not going to be able to sign the petitions and agree to it. This is going to take a number of months. Statutorily, adults in their retirement years, you don't have small children at home, so this could go through in 30 days, but rarely does it. If guardianship, because capacity has declined and we're under a guardianship, you actually have to get permission of the court. There's a lot of interviews. The judge signs off of that in the guardianship court before it can even go to the divorce court. Then it has to go back to the guardianship court again. So that can take a lot of time. So, lots of reasons in my mind to avoid that option, but it is legal to do it. One can refuse to pay for the spouse. When you exercise that one, and I'm only telling you this because if you do any research, you'll find the refusal to give care is one way you'll see it listed. Medicaid will penalize the healthy spouse. So yes, your willing partner will get the benefit, but then Medicaid holds it against the one who refused to offer care and pay for their spouse, and therefore you will be denied benefits in the future. So that's a couple of ways to do it. But as you can see from tonight, and I just try to sketch the surface, mainly to give everyone hope, because the primary message we all hear out there is nothing can be done. There's at least two methods. I showed a 50% savings and 8 ways to save the house. There's way more than that, how to avoid spend down. So my question would be, why go through the divorce? Wife would say, well, there's lots of reasons I'd go through divorce, Scott. He's stuck with me this far, so maybe she'll hold into the end. Question though, thank you for that. Let's see another one, $19,000 per year or per lifetime, talking about the gift tax. It's per year, per person. So I'm going to give an example, hopefully clear this up. I have 3 children. My wife and I each could give a child 19,000 every single year. So I can give 19,000 the first one, 19 the second, 19 the third. My wife could turn around and give 19,000 to each of the same 3, and then we can do it again next year. And in fact, there's no limit. It doesn't just apply to children. I could give it to neighbors. If I had 50 friends, I could give every one of them $19,000 a year. The 19,000 is not a rule that says anything above 19,000 then is taxed. If I go to 19,001 penny, only thing triggered at that point is I now have to report it. What happens in the reporting in the tax form is the IRS tracks it throughout my lifetime, and then at my death, they count my entire lifetime. And if over my lifetime, my spouse and I have jointly given away more than $27 million, which I'm very close to, believe it or not, this only impacts 0.01% of the population has that kind of money. So it's almost impossible to give away that much. But all that is being required, if I go above the 19,000, is to report it. So I have a lifetime accumulation. And in the big, beautiful bill, President Trump, it was set to end this year, December 31st. He's extended that indefinitely. So we're not to worry about it, at least for a few years again. But then the question comes, what if I fail to report it? What's the penalty? There's no penalty. So the $19,000 gift tax limit, in my mind, is one of the most ridiculous rules that we have. You're not going to pay taxes unless you have more than $27 million you gave away. And if you fail to report that along your lifetime, there's no penalty for even making that error. So, but it is an annual 19,000 reporting requirement. If one spouse needs long-term care, can you transfer all the assets to the other spouse via trust? Yes, you can, other than the type of trust I was using tonight. So just a little bit of clarity here. It's 138 different types of trusts that I have counted myself. We're talking so far about, I would just say, a grantor trust with some special provisions on it. Often they're called Medicaid Asset Protection Trusts. But there is a different type that your question sounds a lot more like. This is called a spousal trust or spousal lifetime beneficiary trust. I could put everything in the trust and I avoid this 50-50 spend down, anything else like that. And that would allow my spouse to have all of that money for her lifetime. However, it's going to be counted for her should she need the Medicaid benefit. In the kinds of trusts I was talking about earlier in my illustration, she could place hers in the trust, but only after I'm approved for the Medicaid benefit. I have to exclude my part first, or else it's going to result in a penalty. So I would imagine that already I'm a little confusing in what I'm saying here. Let me make this clearer. Other than a spousal benefit trust, which she could lose the money with later on, but it would grant me immediate eligibility myself, a trust does not exclude the asset. Let's think about a fireproof safe. If I go rob the bank and I take the money from the bank and I put it in my fireproof safe, is the money protected? Yes. The money is safe. That's what a trust does. It protects it from outside grabs. But the fact that I robbed the bank, I'm still going to be penalized for it. The same thing applies to Medicaid. I still have a penalty and I have to do these other legal steps to offset the penalty. So the trust itself isn't what's providing the exclusion, it's only providing the protection. So, no, your method won't work in most types of trusts. But what you do is you put tools together so that you get the protection and the exclusion. That's really what we do for you. All right. Next question here. When you savings, does that include 401ks? So let me talk about a 401k. The second part of the question is going to be spot on. We heard that the institutional spouses distributions, Medicaid cannot touch that. It's actually just the opposite. Okay, so here's the way this works. Excludes the principal of my 401k or my IRA. So I'll give you two examples. Let's say the first one is if I'm single. The second one is if I'm married. Single, I have a $200,000 IRA. Medicaid does not count that $200,000 when they do their asset calculation, where I'm only allowed to have $2,000 to my name. So no spend down required. But they do require that I begin the distributions out of that. I may not be to the 72 and a half required minimum distribution age. Doesn't matter. Medicaid requires I start those distributions anyway. Now it comes over into my income stream, and my income stream distribution does the nursing home. So I do lose that income. So if I'm doing planning for a couple, what I'm going to do is I want to draw out that 401k and move it out of a wrapper, because I call that those distributions, the required minimums, the RMD bleed that you're going to lose to Medicaid sometime in the future. I want to move it into trust, reinvest it, and that is going to trigger a tax event. But over time, you'll have a better return on your investment. Your taxes will not be as high as the $9,000 a month nursing home bill in most cases. And there is a tipping point for this. Too complicated to get into right now, but that in the calculations I do in planning for couples. Should we leave it in its deferred tax wrapper, or do we unwind it over time so we minimize the tax and avoid the RMD bleed? But the institutionalized spouses distributions, Medicaid won't touch. They just require you to spend it on your own care, so you lose it all. Now, if it's the community spouses IRA, doesn't matter. They get to keep their distributions, no trouble. How can you guarantee a Medicaid eligible bed when you need it? Aren't these beds limited by the nursing homes? Aren't they limited availability in a geographic area? That's what they'd like for you to believe. You're part right and part wrong. You cannot be Medicaid bed because there are, in every area I've looked at in Kentucky, there are less than one bed is less than one bed per 100 senior citizens. Now, think about that. 70% of us need care, but there's only bed availability for 1% of us. So it can be hard to find the beds. So you cannot be guaranteed the bed. The nursing homes play a game. They play lots of games on this bed issue. And here's the truth of them, okay? When a nursing home opens and they say, we will be able to accept Medicare, they automatically seek certification for Medicare and Medicaid because they are one and the same. So you do your enrollment through Frankfurt and you get your licensure to be a Medicare recipient. At that point, you are saying to Frankfurt in the licensure process how many beds you have. Excuse me. You are not saying how many Medicaid beds you have. There is no such thing. You certify all beds in your facility. So I have 110 rooms. How many Medicaid beds you have? I have 110. You go to the nursing home, though, what they're going to tell you is, well, there is one exception to that. Let me just take that back. Medicaid eligible beds have to be semi-private. That is two per room. A private single bed per room is not, you cannot get a private room paid for by, that's usually not what the nursing home is going to go through with you. What they try to do is they look at their profit margin, because if Medicaid pays for the bed, there is a negotiated rate and it changes based on the number of beds they have available on a monthly basis. But let's just say, generally speaking, they're going to pay about 40% less than what you're going to privately pay. So you're paying $9,000 when you're paying for it out of your pocket. Medicaid kicks in and all that Medicaid's going to pay is around $5,500, something like that. So in order to keep the profit margin in the nursing facility, what management tells the business office to say is you're only allowed to use this many beds this month for Medicaid. And so hence comes the lie. We only have 3 more Medicaid beds available. No, you have 110 Medicaid beds available. You're just only willing to accept Medicaid payments, which is technically illegal. And there's a process you can go through at Frankfurt and force that. But ultimately, it's not going to do you any good unless you're already a resident in the facility, because they have a right to refuse to accept you as a patient until you actually are admitted to their facility, and then you have some leverage to them. But it's going to be a nasty fight, and that's not often something people want to do because you're trusting them to care for you while you're also suing them in court. So sometimes you have to pick your battles, right? So the second part of your question there, they're limited based on geographic area, does look at that. They're trying to control where the distributions are, but I think there's a larger context for it. Question, can you clarify Medicaid cannot touch the 401k? Good question. I can clarify that Medicaid won't touch the 401k. They would like to. So here, I'm going to talk out of both sides of my mouth. The rules say that they can. And I don't know how to give a real good example for this. There are lots of rules that people don't understand that can't go through the particulars of this to make it happen. Medicaid says that anything owned by the recipient while receiving care is eligible for them to claw back under estate recovery. But you have to have the legal mechanism to do that. And what's going to happen is estate recovery isn't going to start until after the person has passed away. The moment person passes away, the new owner of the 401k is the named beneficiary, whether that be the spouse or the children or the Donald Duck Corporation or wherever you send your 401k to. So there is no legal mechanism to enforce their crazy rule that says, oh, yes, we're entitled to that. Good. How are you going to do it? You can't get blood out of a turnip, right? So technically, the rules say it's available because it belonged to the Medicaid beneficiary while they were still alive receiving the benefit, but they have no legal mechanism to do it. And this is a thing called conflict of laws. A lot of those in the US where just because one law says you can do it, the other sets of laws prevent it. So they will not be able to come back after a 401k. period. The other thing there, that QR code on the screen, that is a way for you to actually give a um, Google review, if you would. All you have to do is hold your cell phone up, take a picture, and that push the little yellow button that pops up, and that'll let you give a review. The purpose of doing that isn't for my benefit. What it does is when you give a review, Google will push this stuff out to more people. There's a wider net who become aware that we're doing these free webinars and the kinds of we offer. So it helps other people. It doesn't help me. I don't get anything from it except just an opportunity to help more people, which I really relish. So you can contact us in any way. Um, Thank you again, and I hope you're safe throughout the week, and we'll see you next time.